All right, good afternoon, everybody. Thank you for being here for the July What's Up with Us. I am one of your hosts today, Ashley Peterson, and I have Jennifer Swanson, my awesome friend and colleague, who is filling in for who you realize is probably missing, Neil Kalin. So Jenny is stepping into Neil's big shoes today, and we hope that we'll do him some justice with our presentation. So let's get to the agenda. This will go, there we go. All right, so we got three cases to talk about today. And we have a lovely interview with Cheryl Dunn-Soto, our beautiful guest here today, who Jenny will be interviewing shortly as well. And we will hear from her and her experience and her background, which is very interesting. So without further ado, we will jump in with what's up with Neil. So where is Neil this month? Since he loves to do this to me when I am not here, he does PowerPoint slides with my face photoshopped on cartoons. So I am doing a little payback to Neil this month because he is super busy and could not make it this month. He's swamped, so that is me making fun of Neil. So Neil, I hope you get all your stuff done that you're supposed to get done this month, because I know you are very in demand all the time. But as he mentioned last month, I moved to Austin. My fiance got a job out here. So in the last 3 weeks, I have transitioned my entire life from San Diego to Austin. So I am here in the 100-degree heat, and it's not as cool as San Diego. But
it's pretty warm in San Diego still today, though. It's a good 90-something degrees where I'm at.
Really? Yeah, okay.
Yeah, and a little bit humid. So I think you sent some of your thunderstorm weather this way. Yeah. Thank you for that.
It's cool though. There's weather out here, which I really liked. So that's been exciting to have thunderstorms rolling in the middle of the day and just seeing, lightning. So yeah, it's fun. Okay, so here is our first case, which is, of course, this is going to block it here. City of Austin versus Reagan National Advertising of Austin. I thought this case would be very on point since I literally just moved to Austin, and it was a very interesting Supreme Court case. So this case in particular deals with sign regulations, and the City of Austin has regulations relating to on-premises versus off-premises signs. And the way that they sort of define those terms is that things that are not located on the same premises as the sign or direct people to different locations are deemed to be off-premises signs. So in this case, there was a distinction between new off-premises signs and on-premises signs. So you could not construct new on-premises signs, but there were existing ones that obviously were in place before this statute or ordinance went into effect in 2016 that said you could not, you could be grandfathered in if you had an existing sign, but then it could not be altered. So the terms that they said was you could not change the technology, you couldn't change the digitization of the sign, or increase the illumination or the nonconformity of the sign. So there was some interesting language that they chose to specifically keep the grandfathered signs from doing anything to basically modify their existing signs other than what was already there. But on-premises signs, there was no restrictions. You could do whatever you wanted with those. So
Ashley, for on-premises signs, when I was reading it, I'm wondering if you had the same kind of, to drill down on that a little bit, was like if I have, a In-N-Out, which I guess you wouldn't in Austin, but if there was an In-N-Out, In-N-Out could have a sign because In-N-Out was the on-premises business, right? But on that same pad with In-N-Out, I couldn't necessarily have a sign for like the furniture store down the street because that would be off-premises, right? That's the distinction that they were drawing. So you could advertise the business that was there, but not, a billboard to go to the mall or something else that wasn't already there. Okay.
Yeah, that's how I understood that as well. Yeah. So the defendant in this case, the Reagan, was a billboard sign company who had applied for permits back in 2017, which that shows you how long it takes a case to get to the Supreme Court. So they applied for permits and were denied because they wanted to digitize some of the grandfathered signs that they had around the city. And they claimed that digitizing the signs, should have been permitted under the code. So obviously, since they were denied on the permits, they filed suit in state court alleging that the city's prohibition against digitizing these off-premises signs, but not restricting the on-premises signs, violated the First Amendment of the Constitution. So the city then removed the case to federal court, and the district court held that the challenge sign code provisions were content neutral under a prior case that was a Supreme Court case, Reed versus Town of Gilbert, and that the district court reviewed the sign code under intermediate scrutiny and found it met the standards. So they said it was basically content neutral because it didn't impose restrictions based on subject matter of the sign. It was just, on premises versus on premises. It doesn't matter what the sign said. There were no regulations about the content. So then, of course, it was appealed, and the appellate court actually reversed the district court's decision and held that the on-premises distinction was facially content-based, because they said that a government official had to actually read the sign's message to determine whether the sign was off premises or not. Because if you're looking at a sign, you have to see, oh, is it directing you down the street or to a different location? So they believe that strict scrutiny should have been used here because it was a content-based restriction. So it went all the way up to the Supreme Court, and the Supreme Court was basically in line with what the trial court's decision was, in that the on and off premises distinction was facially neutral under the First Amendment. They believe the Court of Appeals was too extreme in its interpretation of the Reed case precedent, which, if you look at the facts of the Reed case, it was significantly different than what the Austin City Code said. In fact, in Reed, it was a lot more content restrictions in what could be put on those signage. So the Supreme Court said that the city ordinance did not single out any topic or subject matter for differential treatment like it did in Reed, and it was more of a time, place, and manner restriction, which didn't require strict scrutiny. So they reversed the appellate decision.
I think this case is so interesting. So constitutional law, and especially free speech, you didn't know this when you picked this case, but I love that. And I don't practice anywhere in that area. I never do, but I remember it from law school, and I always think it's really interesting. And what I remember most from law school was, the very first analysis is this content neutral? Because then obviously what scrutiny to apply, which is the whole argument here. And I'm reading this and thinking, but is it really content neutral? Like, I can see where the dissent is coming from, because what the appellate court found, which is you do have to look at the content of this sign. Yes, the content is related to the place in this instance, but it is still the content of the sign. So then, I can just imagine some really great discussions in law schools going forward about what is content, and should this really be a bright line rule that says content is content. If you have to read it, that's it, because that's simpler. Or are you headed down this, slippery slope that people talk about? Now we've said we have to read the sign to determine the place. So what is it next time? Next time it can be, if the sign, advertises a business that's open only on Sundays, is that bad? Yeah, that's time. That's only Sundays. Well, but that might be a church, or, so although I can see, like, logically, and I'm not arguing either way, I'm just saying I can definitely see where the appellate decision came from, where their logic was. And again, with the dissenting in the Supreme Court, because content neutral means you don't look at the content, and you have to in some form here. So I thought really an interesting outcome.
Yeah, I agree with your statements, Jenny. I do see where the other side's argument's coming from in this case, for sure, because yeah, how else would you know it was on premises or not? Just based on you'd have to read the content to determine that. So yeah, I agree with you. Cheryl, anything to comment? No obligation.
Yeah, I totally agree with Jennifer, because when the court found that it doesn't single out any topic or subject matter for differential treatment, well, it does, because the subject matter of the sign is about that business that the sign is on, as opposed to the business down the street. So I have not read the opinion, but I am a little surprised by the Supreme Court's analysis.
Yeah.
Because if you can say on and off premises, then what's to stop you from just saying churches or schools or, you know, X-rated bookstores, you know, that aren't within this geographic region? I don't know. It seems odd.
It's interesting. Well, it'll certainly be the precedent going forward on this case. So
For sure.
we'll see what happens with that.
Yeah.
All right, we'll move on to an interview with Cheryl. So now that's a good lead in for you, Jenny, to take the lead here.
So Cheryl, thank you so much for coming. We kind of threw this at you, I think, last week, and you're gracious enough to be here and to fill in. So I really appreciate that. You are a partner in your own firm, and you specialize in insurance law, both in litigation and pre-litigation dispute resolution, if I understand correctly. That's my 2-second overview. I'd love for you to give us a little bit more detail about what you do, because you're going to say it much more correctly than I will, obviously. So please tell us a little.
Well, thanks for having me, both of you. So I'm an insurance attorney. It's funny because those of us that practice in this area, we cannot agree on what we're called. So you will hear insurance coverage attorney, insurance bad faith attorney. I usually say I handle insurance coverage and bad faith matters. I basically represent policyholders against their insurance companies. I only represent policyholders, and I'm always going against insurance companies. And there are different ways you can do that. Sometimes I write letters and I explain to the insurance company why their coverage denial is incorrect. And sometimes I sue the insurance company and ask a court to determine that denial was incorrect. And so that's largely what I do. And then I also will help policyholders navigate their insurance policies and determine, for example, I handle a lot of D&O policies and E&O policies and EPLI policies that are claims made and reported policies that operate very different than, for example, a commercial general liability policy. And with respect to the claims made and reported policies, there are a lot of issues that need to be negotiated that fall short of a denial. So oftentimes with those types of policies, the insurance company will say, yes, we recognize there's coverage under the policy. However, there's an allocation clause and there's only coverage for 40% of this matter. And even though we say we'll pay reasonable rates, we only have to pay $200 an hour. And so then I will help the policyholder negotiate those issues and get a higher rate, hopefully get more covered. And also I handle CUMIS issues when the insurance company's coverage position is such that their own counsel could somehow steer the case into non-coverage, and then I will help my client get their own independent counsel if the circumstances warrant that.
How did you, I mean, that's obviously a place of law. It sounds very complicated. I know I understand insurance probably much less than I should, but it's so very specialized. How did you end up in this very specialized? Because you were, you clerked in some courts, I think, when you graduated, right? So did that lead to that, or how did you end up here, and what is it you enjoy about it? Why did you stay?
Well, so I had been working as a federal law clerk for almost 15 years before I went into private practice, and I loved what I did as a law clerk. So after graduation, I started clerking, and I love to research and to write, and that is largely what I did as a law clerk. And so it was great. And then at one point, the last judge I worked for passed away, and my husband said, it's time for you to go out into the real world. And so I happened to have a friend who had a firm, and that firm only did insurance coverage in bad faith. And he was looking for an associate, so it was perfect timing. And I will never forget my first week on the job. I was standing by the fax machine, because back then people were still using fax machines, standing by the fax machine, and this corporate client was faxing over 100+ page package. General liability policy was packaged with a number of other things. So this fax comes through. On the first page of the fax, it was from their general counsel, and it said, "Happy reading. I would rather die than read this insurance policy." And I remember thinking, oh my, what have I gotten myself into? And luckily, I love reading insurance policies. I love analyzing them. And what I do is a very intellectual process or practice in many ways, and involves a lot of researching and a lot of writing. So it really was a good transition for me from the courts into that practice. But it was just, so fortuitous that I ended up in this area that I absolutely love. And had I not found it, I don't know how long it would have taken me to, find something I really enjoyed. Because I'm an attorney that I need to feel like I'm on the right side of things. And I think some attorneys, you hand them a case, it doesn't matter, they can argue for the plaintiff or the defense, they're happy either way. I need to feel like I'm on the right side of things. And when I'm representing policyholders against their insurance companies, I feel like I am.
Yeah, I can relate to that, definitely. I'm the same way. I do so much transactional, but when I do help with dispute resolution, I definitely want to feel like my client is the one that is on the right side. And I definitely have a certain bend to certain types of clients, which I won't say because it's not as clear cut as yours, but I understand that. And that's great that you ended up in a place where you can do what you enjoy and that caters to your talents. I mean, and then now you have your own firm, or your partner, you have 2 other partners, right, in your firm?
Yes.
And do they also just do insurance, or is it broader than that at your firm?
No, it's broader than that. So we have Paul Leeds, who was formerly at a large law firm in town, and he has an insolvency practice. So he handles bankruptcies, creditor side, and some debtor side, all commercial types of bankruptcy cases, and debt restructuring and things like that. And then I have another partner, Josh Franklin, who does business litigation and also does some insurance coverage in bad faith.
Great. Yeah, it sounds like a very interesting firm, and that'll keep you on your toes as well. So
I was going to ask Cheryl, what's one of the most important clauses in the insurance policy that a policyholder should read and actually know?
Well, so remember I was talking about claims made and reported policies, like professional liability policies. So all attorneys have errors and omissions policies that are claims made and reported. And the number one thing you have to understand about those policies is that timely reporting is key. And I cannot tell you how many times clients have come to me and said, my insurance company is denying, I got sued. As soon as I got sued, I tendered the claim, but they're denying because I received a letter back during my previous policy period, and they're saying that that was the claim and I didn't timely report that, and therefore I don't have any coverage. And unfortunately, the insurance company is often right, because these policies are written so broadly that if someone sends you a letter and says, you made a mistake, and because of that, I ended up, being damaged. If someone sends you a letter like that, run to your broker, send them the letter and say, do I need to tender this? I think I do, because I can almost guarantee you that you need to. And that's where people get tripped up. So you have to understand how those policies operate, and don't just bury your head in the sand and wait to see if you get sued, because you may find you don't have coverage.
I know some attorneys are afraid to do that because they're afraid their insurance company will drop them if they've tendered a claim. Do you find, I mean, my thought is no, they get lots of claims and they get lots of letters, and they know, and unless you have some exorbitant amount, it's just part of doing business. But any thoughts on that?
My understanding is when you will generally get dropped is if the claimant actually goes through with a lawsuit, and then if you have not been with your carrier for a certain length of time, then you risk being dropped. I don't think it's as common to be dropped because you put the carrier on notice that you may be sued in the future. And that's what, if you tender a letter as a claim, you're basically telling your insurance company, look, there's, they've made this demand, so it's a claim, but we don't know if they're going to sue me or not. And so that's, and the thing is that if you're concerned about your carrier dropping you, you should be more concerned that you're going to be sued for millions of dollars and you're not going to have coverage because you didn't tender it in the first place. So people tell me they want to hire me to tell them whether or not to tender something. And I generally say, you know what, you can pay me to do that. And in the end, I'm most likely going to tell you, yes, you need to tender. So
just do it, just tender it and move
yeah.
forward. Yeah.
Tender early and often.
That's great advice. Good practical advice. Switching gears a little bit, my next question was going to be, what is interesting? What's most helpful to the people on the webinar, which is probably that, actually, since we're attorneys. But I'm going to kind of tweak it a little bit and say, where do you see what's helpful to real estate attorneys? But my real question is, do you see crossover between real estate and insurance? And when do you see most of that crossover? My thought goes to premises damage, and we're going to argue over who's responsible for it, and everybody's going to file a claim with their insurance companies, and everybody's going to argue. But is that really where you see the most, or where do you see crossover with real estate?
So where I generally see crossover is I handle a lot of cases involving liability policies. So those cover my clients when they're sued. And so I've represented a lot of real estate brokers, also sellers of real estate who've been sued over the sale of real estate, and they make a claim. Sometimes homeowners, they'll make a claim under their commercial general liability policy. The agents will make a claim under an errors and omissions policy. And so that's where I generally see that intersection. But I also will see, because I have represented developers and contractors, and of course something happens with the property that they're working on and they get sued, and insurance kind of drives the whole construction industry. So I do see that crossover as well.
All right. Did you see crossover? Have you done much with the COVID cases? I know I see a lot, and in fact, the next case that we're going to be talking about is COVID related, which is where I'm going with this. And that one is specifically a lost rent, as a business income, lost business income claim. But, what about like force majeure or lost business for contractors? Have you seen any of the COVID claims coming, and what are you seeing if you have?
Well, I'm curious, is your next case the Inns by the Sea?
No, but that was cited in the next case.
Okay.
Yeah.
Well, so, during COVID, when it first started, I got a lot of calls from business owners, and they would say, I was either like, should I tender this business interruption claim, or I received a tender and it was denied. And it was interesting because some attorneys were saying, oh, yes, there's coverage under commercial property policies for lost business income because of COVID. And I kept saying, I don't see it. I really don't see it. And because the problem is that these policies, they require that the suspension of rents or the business interruption loss be the result or be caused by direct physical loss of or damage to property. And the courts have said that means physical loss of property or physical damage to property. And unfortunately, COVID doesn't alter the property. It doesn't like go in there and somehow change the properties of that particular material or that particular asset. And it doesn't alter it in any way. And you don't physically lose anything. There's not a physical cause of loss. You're unable, you lose the use of the property, but the term physical is so important. And I was telling everyone, I said, I understand back east, the law is different. I sit under California Supreme Court law. I think that the vast majority of these denials are going to be correct under the law as it currently stands. And it's going to take the Supreme Court to change the law. And then the ends by the sea case came down at the end of 2021. The Supreme Court refused to hear it. And it basically confirmed what I said, that under the typical commercial property policy, you're not going to have coverage for COVID business interruption loss.
Right, which is really interesting. I think maybe if Ashley's up for it, what I want to do is go to the next case and then finish up my interview with you, Cheryl, with what do you like to do on a personal note? But because the next case, I cannot remember the name of it without the slide up, but it is exactly that was a distinction they drew. Was here it is, Musso and Frank Grill, and it was physical loss, and the loss was caused by the public order, which was caused by the virus, and the virus wasn't public loss. And I think they didn't they quote the ends or cite the ends by the sea when it finally got to the appellate level, Ashley? I can't remember, I read it this morning, but.
Yeah, I'm pretty sure they did. Do you want me to do just a quick summary of the case real quick, and then we can get Cheryl I mean, she pretty much gave her opinion of how this came out anyway, but we'll jump in. But this is Musso was an iconic Hollywood fine dining restaurant. They had business interruption insurance issued by the insurance company. And obviously due to public health emergencies, the governor, mayor, etc., everything had to close down in Los Angeles and California in general back in March of 2020. So they lost all their business. They weren't even able to do takeout orders because of the Los Angeles restrictions. So the restaurant filed a claim with the insurance company due to the business loss. And as Cheryl noted, they were denied on the grounds that the policy only covered direct physical loss or damage to the property, and there was expressed language in their policy which also included government action for viruses or bacteria, which, Cheryl, correct me if I'm wrong, but that's fairly unusual for an insurance policy to have language about the virus or the bacteria in there. Is that true?
It's becoming more and more common. So especially after COVID,
yes.
Yeah, but even before COVID, it was not unusual to see that. It maybe wasn't typical, but it wasn't unusual.
Okay. I had never seen that in any of the commercial policies I'd seen, so I was curious. Okay. So the trial court, obviously the restaurant sued the insurance company, and the insurance company filed a demurrer, which was sustained without leave to amend in the trial court. Musso appealed. And so I wrote in here, it's worth noting that at the time of the trial court's order and at the time of Musso and Frank, none of the COVID-19 business interruption cases that were discussed in their opinion had been filed. So this was the ends by the sea in November 2021, which postdated the trial court's order and the opening brief in this case. So the appellate court commended the trial court by saying that basically they reached the same result that the Supreme Court was going to reach essentially in this case. That there was no physical alteration of the property, no physical loss to justify the insurance payout on the claim. And obviously closure due to a pandemic was not based on any physical loss or damage. So in this case, the insurance exclusion applied and they affirmed the trial court's decision. So as I wrote at the bottom there, the very first published case to address this in the context of COVID-19 pandemic was this Oral Surgeons versus Cincinnati Insurance, and that came out of Ohio, I believe. Yeah, I think it was Ohio. So Iowa, I'm sorry, but even though it wasn't California law, the facts were extremely similar in those cases. And so I think it's interesting that we've started to see a lot of these COVID-19 commercial lease cases come down the pipeline and actually see how they've been decided.
And I think based on this case and ends by the sea and what you're saying, Cheryl, we should just expect that, too bad, if you had an insurance policy that was in place, you're not going to get your insurance to pay for it. I mean, have you seen any other result than that, Cheryl?
Not in California, no. Not that I'm aware. Now, the one interesting thing is because in connection with preparing for the podcast, I did do some research on this, And apparently there's insurance now that's called rent guarantee insurance. And it's quite common in Europe, but it's very, very new here. But if anyone is, concerned about what may happen in the future with the next virus that comes along, they may want to, ask their broker if they're familiar with this type of insurance and see if they can't get it. It's not cheap, but it sounds like that may be a way to get coverage for these types of situations.
And that sounds like that may be something that maybe commercial landlords would want to look at, having their tenants, or at least their bigger tenants, requiring them to carry that as well. Exactly. Because it gives them interesting rent guarantee insurance. Great, I did learn something new today.
Something we can pass on to our commercial clients, Jenny.
Exactly. So thank you for your thoughts on that, Cheryl. It was great. Good, wonderful segue. I'm going to go back to wrapping up the interview though, and say all the work stuff aside, if you're not working, I know you like to drive fast cars, and we have that in common. As we've talked about your Mustangs and Corvette before. What else could we find you doing on a Saturday? What do you like to do when you don't have to work?
Well, on a Saturday, you'll probably find me working, but what do I like to do? My husband and I really like going to concerts, and we are products of the 80s. And so we love going to concerts that have 80s bands performing. So for example, last night we went to a concert where Loverboy, REO Speedwagon, and Styx performed, and it was a fantastic concert. So we go throughout Southern California and sometimes over to Vegas to hear 80s bands.
That sounds great. My husband would love that. He loves 80s bands. We went and saw Hart and Joan Jett. I think maybe it was pre-COVID. It was very cool. So,
yeah, I've seen them touring.
Very cool.
What's the car relation there, Jenny, that you were talking about? That you guys both race cars? Does she do that too?
Cheryl doesn't race cars, but she does love the fast cars. And you've had a couple of Mustang 5.0s, right? Mm-hmm. And the first time that I met her in person, we were going to a meeting together, and I hadn't seen her, didn't put the face together, but she pulls up in her snazzy little 2005 Corvette convertible. I think it's 5. And I go, do you like your Corvette? And she goes, are you Jenny Swanson? We hit it off. That was it. So yeah.
No way. See, look how famous you are, Jenny. For those who don't know, Jenny actually races cars, which is pretty freaking awesome. So I have to say, you're pretty badass, Jenny.
And she doesn't just race them; she works on them.
That too.
She gets under the hood and works on the engines. So
that's true, which is also for better or for worse. Sometimes I think, why am I doing this? It'd be so much easier if someone else did it. But it's fun. It's a good family thing too. My daughter does it with me, and my dad does it, and so it makes it lots and lots of fun.
That's awesome.
Very cool.
Anyway, should we move on and get our last case in? I don't want to keep us from, I guess we have plenty of time.
We're actually ahead of schedule today. We're talking so fast. But maybe this one will spark some more interesting conversations, because I found this one to be very interesting when I was reading through it. So I can't, of course, see the title here. Can you read it for me, Jenny? Because it's covered up on my screen.
Berman et al. v. Freedom Financial New York.
Thank you.
Freedom Financial Network, LLC, sorry.
Yes, thank you. So this is a Ninth Circuit Court of Appeals case, and this just came down in April also. So the plaintiffs, there were 2 of them, they visited 2 different websites while they were browsing that contained hyperlinked terms and conditions, which had a mandatory arbitration provision. So the website or the company Fluent, they offer gift cards and free product samples, and if you complete a survey, you get things in exchange for providing your contact information, and they use that for targeted advertising. So the website, you just scroll through, and the way that they were describing it is basically you have to enter all your personal contact information to be able to move on to get your, free stuff. So you're scrolling through, enter your name, enter your zip code, enter your email, and you're clicking through on that, and you say continue. And so in the little tiny gray font, there's a hyperlink thing which says I agree and understand to the terms and conditions, which includes a mandatory arbitration and privacy policy. So the users had to actually just click continue by filling out the forms requesting their information, but they weren't actually clicking a separate box agreeing to the terms and conditions. So those were just hyperlinked listed on there, and they were clicking through adding their personal information. So this lawsuit came from the fact that the plaintiffs filed a class action on behalf of consumers who were receiving unwanted calls and text messages from the defendants during a telemarketing campaign. And I can't tell you how many telemarketing calls I get a day now, but it's super obnoxious. So I commend them for filing a class action suit on behalf of that and preventing people from doing that. But they claimed it violated the Telephone Consumer Protection Act. And so the defendants claimed that, clicking the continue box when you're clicking through with your personal information was sufficient to prove that they assented to the terms and conditions and the mandatory arbitration. And there was also something in there, I guess, that everyone agreed that either New York or California law applied. So the case actually said that either one of those states require for an online contract to be valid that the parties have to manifest their mutual assent to the terms of the agreement. And it talked about how there were these click wrap agreements where you actually see a pop-up box saying, I agree and check the terms and conditions, compared to a browse wrap where you are only seeing the terms and conditions disclosed through a hyperlink. So the click wrap ones have been held enforceable by courts in the past, whereas these browse wrap ones, like this case, are deemed to be less enforceable. So you have to basically show that the consumer had actual knowledge of the arbitration agreement, and were given conspicuous notice. So at the trial court, the defendants moved to compel arbitration. The district court denied that motion to compel arbitration, and they held that the content and the design of the website did not conspicuously indicate to users that by clicking continue, they were agreeing to the terms and conditions. So the defendants then filed a motion for reconsideration based on testimony from the plaintiff's depositions, and the motion for reconsideration was denied. So at the appellate level, they reviewed de novo the denial of the motion to compel arbitration. The appellate court really kind of slammed down the defendants on this holding, because they were saying that they could have introduced this deposition testimony of the plaintiffs during their first motion to compel the arbitration, or even depose the plaintiffs prior to briefing the motion. So they waited to present this deposition testimony until the court had already made its ruling. And so they determined that the motion to reconsider is something that's only used as an extraordinary remedy, sparingly in the interest of finality and conservation of judicial resources. So they said reconsideration motions may not be used to raise new arguments or introduce new evidence if, with reasonable diligence, the arguments and evidence could have been presented during consideration of the original ruling. So they really slapped down the defendants in their holding. They affirmed the district court's denial of the motion to compel arbitration, and further confirmed that there was no conspicuous notice to a consent to this arbitration agreement based on this browse wrap hyperlink terms and conditions. So,
yeah, I thought it was really interesting in the facts of the case, like the browse wrap. They said not only was it browse wrap, which I thought was what a cool new term that I have now learned, because I've heard of click wrap, but browse wrap. And how complicated would it be to be a web designer also, by the way, because you got to know all these things. But that in this particular website, the hyperlink wasn't even highlighted or underlined or different. And the court said that, consumers can't be required to hover their mouse over otherwise plain looking text or aimlessly click words on a page in an effort to ferret out hyperlinks. And I just had this picture of us like randomly clicking on all the words to be, I thought that's so funny. And I have to wonder too, did they being the designers have that thought? Like, we really are trying to be, because it feels like they're trying to be sneaky. We could put a checkbox. It's not harder to put a checkbox when you're designing a web page, and it's not harder. In fact, I think it automatically makes it blue and underlined. and they didn't do those things. And so that, to me, it just feels like they're purposely trying to be a little bit sneaky. And to what end? Because everybody, or 98% of us, are just going to click the box and hit continue anyway, right? So I thought that was really interesting. And the other side of it, like you were saying, Ashley, is that they did not bring in the deposition testimony until after the ruling. And the court really did say, you know, you could have introduced this in your motion to compel arbitration, and you didn't. And, you know, that is, sorry, there's construction. I hope that's not too loud for you guys. That is not what you can use this reconsideration motion for. You had the chance, you should have done it then. Too bad. So this case is really interesting because not only do you have the actual facts of the case, but you have kind of the procedural decisions that was made as well. And I think both of them make a lot of sense to me.
Yeah, well, and the reason they were trying to introduce that deposition testimony is to prove that the plaintiffs knew that they were, you know, agreeing to an arbitration, mandatory arbitration, which, you know, I guess they said something in their deposition testimony that might have supported that, but was that enough to, you know, prove they had actual knowledge and conspicuous notice? I don't think so. But
and it probably wasn't, or they would have just introduced it with the motion to compel, right? But what other reason would they have not to include that?
Right.
Say the two of us non-litigators.
Yeah. I mean, I think about all the times I go through websites and I just click the agree to the terms and conditions box because you have to if you want to move forward. So have I ever read those? Maybe a handful of times, and that was it. But no, we lawyers are even worse about that, I guess.
Well, and if you don't agree with it, what are you going to do?
Right.
You know, it's like, it's funny because we lawyers, when we do, you know, when you buy a house or you do finance a car, you're either going to want to buy the house and finance the car, and so you agree to it, or you don't. You don't have, and we want to negotiate everything. So what do you think, Cheryl?
Yeah, I agree. I mean, I remember the very first time I bought a house by myself, I literally read through every single document that escrow put in front of me. And I think they're ready to shoot me at the end of like 2 to 3 hours, because literally, and I asked questions and I said, I want to know, this document refers to, you know, an easement. Like, what easement is that? And what is this? And I drove them nuts. And then after that, I was like, okay, you know, I want to buy the house. I've got to sign.
Yeah,
that's what it comes down to, right?
Yeah.
I think a lot of it too, though, is just you read it and you understand it. I know it's there. And even then you're like, yeah, what are you going to do? Right. So.
Yeah, you just don't want to be, I mean, you understand how non-attorneys don't read that stuff, but you don't want to be the attorney that says, oh, I didn't read it. You know, because maybe the average person can get out of something by not reading it, but they're going to hold us to a higher standard.
Exactly. At least if we read it and said, okay, that's there, I'll just deal with it. That's a risk I accept.
Yeah.
Yeah, exactly. But if I can't even find it because it's not even highlighted and I have to randomly, aimlessly click through the website, I think that's definitely a different deal.
Oh, yeah. For sure. Yeah. Yeah, I've never seen that before. And that sounds highly calculated to cause people to end up in arbitration.
Yeah, I agree.
Which is not cheaper and quicker. Certainly not, maybe quicker, certainly not cheaper.
Right? This is what I'm hearing. And especially my understanding is, depending on how the arbitration clause is written and what's in there, it can be just as much discovery as you would have in the court and just as long. So, you know, these are the war stories that I hear from our litigation partner.
So it depends upon what arbitral body that you're dealing with, but you're right. Some of them, there's a lot of discovery. In insurance policies, I always tell clients, do not purchase an insurance policy that has an arbitration provision in it, because I guarantee you that the insurance company will act even more unreasonably if there is one. And I know a certain insurance company, they like always have a provision that requires 3 arbitrators, 3 AAA arbitrators. So you have 3 arbitrators at, you know, $500 to $800 plus. So you've got three arbitrators, and then you're looking at, you know, $5,000 to $10,000 to file the lawsuit. A policyholder can go into federal court and for like, you know, $400 or $500 file a lawsuit against an insurance company and get a free ruling from a court. But your client may spend a few $100,000 trying to get a ruling from the arbitrators who don't even have to follow the law and who get cases from these insurance companies day in and day out and may see your client never again. So yeah, I am not a proponent of arbitration clauses, particularly in the insurance context.
That's really good to know. I mean, because like Jenny and I don't do much litigation at all. So having that clause in our contracts is something that most clients want, you know, and because of what I've been hearing from other litigators is that it's really not that much cheaper, and you end up getting decisions that you are not happy with because they don't necessarily follow the law. So it sounds like, you know, moving away from these mandatory arbitration provisions might be the better way to go for clients.
Yeah, my partner and I have given seminars before where we've said whether or not you want an arbitration clause in your contract depends upon if you think that you're going to be the one to act badly. If you're going to act badly, then put it in. And if you think that you're probably going to comply with the terms of the contract, leave it out.
That's interesting. That's it. Really kind of, and of course everyone should say leave it out, but there's those people like insurance companies.
We had an attendee write a question. They said, do we know of any cases that discuss the concept of contract of adhesion for making these types of disclaimers or agreements on web pages unenforceable in the same way they're deemed unenforceable when included on the back of a parking ticket, etc.? I don't know anything about that, so. I
don't know either, but it's interesting because I had that same thought when I was reading it. And I was reading the case, I was thinking, you know, it does sound like a contract of adhesion. And I was thinking that again as we were talking about it. And I think I'm the one that said, you have to click on it if you want to move forward. So I'm sure that I would not be surprised if there were ones like that. But the court did say in this case that they have found the click wrap to be enforceable. And that's where you check the box and say continue, but you have to do it to continue. So maybe the difference there, because that's maybe not a contract of adhesion because it's obvious and you have to check it, like the ones on the back of the parking tickets, if I'm remembering the cases back right, are, you know, people didn't always see them, didn't always notice them. They're just kind of hidden there, more like this browse wrap is, as opposed to the click wrap where you have to click the box so you at least know the contract is there. But to me, it's all the same. You know, you have to do it. I think we had another one come in also, Ashley.
Yeah, they're asking how successful it is in getting insurance companies to agree to waive the arbitration provision.
I think it depends upon the insurance company and the issues, but a lot of times the insurance companies insist upon arbitrating because, you know, it causes your client to think twice about whether or not they want to spend all that money and take the chance of losing after spending hundreds of thousands of dollars. So typically the insurance companies enforce them.
Mm-hmm.
At least that's been my experience.
And an insurance contract, in my experience, is always, you know, you can't say, yeah, I'll take this, but you need to delete this arbitration clause. Or do they have a writer for that takes it out if you ask?
Yeah, you can oftentimes negotiate it out before you purchase the policy. Okay. And I've seen it negotiated out. For example, Scottsdale Insurance Company, I've seen them routinely negotiate that out, but you have to ask. You know, so I think it depends on the insurer, but you should absolutely ask the insurer if they will take it out before you buy the policy.
This is going on my checklist.
Yeah, seriously.
At home and at work, for sure.
Tips, Cheryl.
Yeah.
All right. Well, I think we are getting close to the end here, so we should probably, Jenny, let people know what's coming up and how to get involved. And first off, I want to say, Cheryl, thank you so much for being here. And I know if you have things to do and you need to jump off early, by all means, please go ahead. But you've been a wealth of knowledge, and I know Jenny and I have some takeaways from today for sure. So
Well, thank you so much for having me. I really appreciate it.
Thank you so much, Cheryl.
And I'll just stay. I'll stay to hear the rest of this.
Great.
Okay.
Jen, you want to walk us through the upcoming webinars?
Yeah, I will. In fact, since I am the webinar committee person at RPLS, we have coming up this what every non-leasing lawyer needs to know about commercial leasing. And I believe I saw that one, even being a leasing lawyer, and just thought it was a really great webinar. So highly recommend if you're tangentially involved with that, or even just for yourself, for when you need to do the lease for your own office.
Isn't that Joanne's seminar?
I think it is.
Yeah. Joanne Newsom is an amazing speaker. So if you are interested in attending that seminar, I definitely recommend it. She's a great one.
She is great. And I think there's another one coming up. We don't have the date on here that Joanne is also doing. That's not a rerun. It's going to be a live one in October. And I apologize, we don't have the date, but keep your eyes open for the email blast should be going out. And she is just really great. The next one is the partnering with the litigator when issues relating to an existing lease arise. And actually, I'm one of the panelists on that. And we're going to be doing it. We have our litigator, and we're going to be saying, this is the commercial lease issue. We haven't reached litigation yet, but we think maybe it's headed that way. At what point does it make sense for us, as a non-litigator, to pick up the phone and bring one in to give us the right advice or help us prevent litigation or be prepared for it when it happens, as opposed to waiting until maybe you're actually served with that lawsuit. So that's coming up September 29th. And then of course we have the legal ethics in a remote world. So many of us, like Ashley, are still working remotely and have moved and are practicing in one jurisdiction remotely from another one, and what can you do and what can you not do. So that one's super helpful. And then the Foundation Signature Speaker Series, how to become a judge. So if you're interested in that, some good practical tips there. If anybody has any real estate related webinars that they're interested in doing, whether they want to be a panelist or whether they just would really like to see that type of webinar, email me. My address is up there. And if you aren't interested in being a panelist, but you have an idea for a webinar, I can always reach out to people and see if we know anybody between Ashley and I and the other XCOM members and the other members of CLA, someone has to know and will be willing to step up and do it. So I'm always looking for ideas. Feel free to shoot me an email.
I think we should have Cheryl do one on arbitration clauses.
I think that would be great.
Cheryl, I just volunteered you. I hope that's okay.
Oh, thank you, Ashley.
She does that. I forgot to warn you. Sorry.
Yeah.
Kyle Yigi is the one to contact if you want to get published in the monthly e-news. And that's just a short article. I don't remember. I think it's maybe 250 or 500 words. The e-news is a very short article. And he's the one who can give you more information on that. And then if you have a longer, more scholarly article with all your sites and, the research, this is in the RPLS Real Property Journal. You can reach out to Norm and he can help you with that. They'll walk you through the process and get you, they do a really good job of getting your articles, finding the place and getting them published. So that's all the contact information for that. And then we have the annual meeting coming up here in San Diego. I can't see the information about it because it's behind my screen. And I know, Ashley, you've been involved in it. So I'm going to let you talk about that.
Yeah, it's going to be, like Jenny said, in San Diego. So that's really exciting. I'm actually going to be flying back to San Diego for it specifically, but it'll be September 15th to the 17th. And the last night they're having a black tie gala. So that'll be super fun for everybody to dress up. They have some awesome keynote speakers. I think one of them is from The Office, and I can't remember who the other one was, but they're two very famous speakers who will be keynotes at that event. It'll be a lot of fun and a great way to dress up, have some libations, and hang out with other fellow CLA members. So definitely don't want to miss it.
Yeah, definitely.
All right. Well, I think we are a couple minutes early, which is good. So we'll let everybody get back to their day. But thank you all for being here. Jenny, thank you so much for filling in for Neil and being my great co-host today.
I'm pretty sure I didn't quite fill Neil's shoes, but thank you for letting me step in. I really appreciate it.
Well, and thank you all for being here and attending today as well. So we hope you got some good information. And great, we'll see you all next month on, I can't see my date for that, but it's August 17th at 1 o'clock. So we'll see you all then.
Sounds good. Thanks,
Thank
Ashley.
you.
Thank you.